spokesperson for the Satanic Temple. I'm here again with Haan and Matt Kezhaya, both attorneys that the Satanic Temple works with. And we were doing live streams now to bring people up to date on some of the attacks against us that have become pretty forthright, pretty flagrant, and pretty relentless now, especially now, I assume, because it's election season as well. But last time we were talking about an Arizona bill that was meant to exclude Satanists from public spaces, and a similar one in Iowa. Both those bills are dead for now, but I expect they'll come back in some form in both states. Georgia now has introduced a chaplain bill, and we're seeing chaplain bills pop up all over the place, and simultaneous with bills intended to keep us out of public spaces, there's now heightened concern about satanic chaplains, because we've already put out the notion that if they're going to start allowing chaplains into schools, that we'll be interested in participating as well. Well, Georgia put forward a chaplain bill, while Florida is trying to come to terms with the fact that Satanists will apply if they allow chaplains. Georgia simply wrote into the bill that Satanists need not apply, that any chaplain cannot be a Satanist. In this, I harped on the stupidity of some of the bills in our previous discussion, but this is just another step beyond into egregious stupidity from these lawmakers, because not only is this flagrantly unconstitutional, but again, it has no theory of law to mitigate its unconstitutionality. It gives nothing to a judge to try to address this in a way that they could possibly, I think, view in favor of this bill. It doesn't mean it won't pass, but I'm not sure the judiciary has any means in which to uphold it. And I'm wondering if, in your minds as lawyers, that does this rise to the level of something we can take action on prior to it even being passed? Is there some argument to be made that this is a type of public harassment against us when they're trying explicitly to write laws that exclude us in this manner? It does seem like it's almost it is almost a breach of the public confidence for them to start picking and choosing, even in the attempts of legislation, to segregate a population of people, put them on a lower tier, and thus advertise that it's okay essentially to come at us, disparage our rights, or otherwise try to treat us as second-class citizens? Or is this something we wait on to move forward with? Is there anything proactive we could possibly do?
Nothing legally.
The short answer is no, because there's two issues here. There's an immunity issue for the politicians, and then there's a standing issue for us. So until a bill passes and becomes law, basically when a bill is proposed, what that means is some redneck had two brain cells crash together, and what spewed forth was an unconstitutional idea they want to make law. So to me, when these bills are passed, what it's saying is it's demonstrating what they're trying to do. It's their signal that we have an agenda and we're going to try to bog down the system with stuff we know is wrong, but this is our agenda. Luckily, like in those two bills that happened in Arizona, we'll get to that later. But I kind of just wait and see what happens, because most of these bills will die because somebody with half a mind will be like, wait a minute, guys, maybe singling out and eliminating the First Amendment rights of one particular group might not be a solid idea. But what needs to happen if we're going to challenge it is it needs to be passed, and we need to have standing, which means a redressable issue that is affecting an actual person. Because if there were to be lawsuits about everything that was passed that people didn't like, every politician would be getting sued all the time by everybody. And also all of the grievances would be theoretical or hypothetical. And for a lawsuit that's federal, where that's usually where it goes when you sue the state, there has to be something where one person can say, I was actually harmed by this law. This affects me personally, and that becomes your plaintiff. So until it passes, I don't think legally there's anything we can do.
Agreed in full.
Well, I don't think it will pass. It's hard for me to imagine even the governor of Georgia would sign this, seeing that there's definite problems with it. But at the point where they're writing things and they're unconstitutional on their very face without any legal theory behind it, and it becomes just this kind of wish list writing where they want things passed into law that are even outside their very purview. These large kind of existential questions about what is God seem to be playing into some of these bills. Like in the Iowa bill, when they were trying to limit Satanists from the public sphere, it included this language about how God is universally agreed upon to be symbolic of good, and Satan is universally understood to be the enemy of God. And that already gets into a whole philosophical minefield beyond, well above and beyond what the government should be determining, sitting in legislative halls and writing up bills and that type of thing. And there seems to be a real disconnect between our lawmakers and their actual function, to the point where they don't seem to be working at their jobs at all anymore, or even understand what those jobs are. And I know I went through this last time, but it seems to be a state of affairs that is really under-recognized at this point. Infrastructure falling apart, education falling into the pits, and people just signing their names to legislation that they didn't write and that has no basis in any theory of law, constitutional understanding. And this seems to be the framework under which we're operating now. How horrific of a state of affairs does this appear to be to you? Does this seem to be a real departure from what we've seen in prior years? Or are we just seeing it more directly now because it's aimed at us? That is to ask, has there always been a certain number of conspiracy theorists as lawmakers proposing things that are asinine? Because I know it has happened before. There has been a history of conspiracy-based legislation attempting to be passed, drawing support and things like that. It just seems like it's rapid fire now, and that there's really this push amongst culture warriors to even write bills and propose them that maybe they know aren't going to pass, but are to serve the purpose of tribal signaling. Does it seem like this is getting worse, or does it just seem like it's something we're combating more directly?
I think that it's indicative of a segment of society that perceives us as a threat. If you're not taking flack, you're not over the target, so to speak.
I could call it zeitgeist. I think the pendulum swings back and forth with this stuff, and I think we're noticing it more because it's more blatant. I mean, they're targeting us directly in the law. They're not hiding it anymore. They're saying we're going after these guys. It's not vague or anything. So I think in that way it's pretty alarming. But I feel like this is another symptom of the satanic panic, where I think back in the 80s, it was changing demographics that causes this thing. So, women entering the workforce is why they demonized daycares, for example, and said, these strangers are raising our kids, and then all the conspiracy theories happen. And I think now, because of the internet, you see the rise, so to speak, of like LGBT rights, the immigrant influx of immigrants and things like this. And what happens is the people that are part of the status quo, which of course is most of our legislators, they feel threatened, exactly like Matt was saying, where they feel like this status quo is being challenged by our mere existence, and they need to put a stop to it to uphold what they believe is their own, kind of stranglehold on the system, where it's like, a real American looks a certain way. It looks Christian, it looks white, it looks, whatever it is. So I think what we're seeing is, the fact that they know who we are. And when we started this stuff, all of us here sitting here today, they didn't know who we were. We were nothing. But now they're seeing like, oh, there's these, they have numbers, they have lawyers, they have some teeth, people are on their side. They need to clamp down on it. And I just think this is part of a nation with changing demographics. I think this happens everywhere where there's it's a panic. It's the satanic panic, like 2.0 is what we're seeing here. But it's very alarming because they're demonstrating what they're going to do. And they're going to try to outlaw our very existence, which has happened, in every country, from Japanese internment camps to slavery to everything else, where when one demographic starts to gain some kind of placehold in society, they need to put a stop to it. I just can't believe that they're doing it so openly at this point.
There's a frustrating irony, I think, in the fact that we're always described as though we have these disingenuous intentions. Like we're saying one thing and what we really mean is another. And we even get that sometimes from supporters. There was a article that came out of Utah in regards to their chaplain bill, and it was otherwise an article making the point that we had a good point, and that if they started putting chaplains into schools, we'd have to be there too. But frustratingly, in the article, it described us as giving our tongue-in-cheek support to the bill to put chaplains in schools. And that's not what we're doing. We openly said that we think it's probably better off that they don't put chaplains into schools, but we really feel a sense of duty to uphold pluralism and make sure that there's government viewpoint neutrality in play if they're doing that kind of thing. And so if they do it, we will look to put chaplains in schools. And immediately, what we find is that they openly expose themselves for the liars that they are. When we say we want to participate, well, just moments before, you would hear these lawmakers talking about how it has really nothing to do about the religious elements so much as it has to do with emotional support for the children who desperately need it. And if we can give them an extra empathetic ear from somebody who might be willing to listen to them and might be willing to give them some guidance, then we're obligated to do so. We're obligated to open those doors for those types of volunteers, but not Satanists. And then, of course, that opens up a whole bevy of questions. Well, why not Satanists? If the religion is pretty much irrelevant in this case, and we're sure under some kind of honor system that people aren't going to be proselytizing anyways, and that their concern is just the emotional support, then it really shouldn't matter what the religious viewpoint is. And for that matter, maybe it shouldn't be a chaplain program. Maybe it should be volunteer counselors. The whole argument begins to fall apart. And I think it's funny that they seem to feel that they can argue one thing publicly and then go into the courtroom and argue something else entirely, which also shows a complete ignorance of the law. This behavior can be entered into evidence as well. And with that in mind, I wonder if them writing in the Georgia bill that they're specifically trying to exclude Satanists up front is actually beneficial to us when we go into court later. If they try to narrow it down to try to keep us away from the chaplaincy program by putting more restrictions and more requirements upon it, more in that ones that seem more generally focused towards people with a Christian background or some denominational background of that type, then I think it's kind of difficult for them to say that they were never trying to keep Satanists out.
Well, yeah.
What are you I mean, is it actually a benefit to us that they're acting so flagrantly hostile towards us and openly?
Well, if you look at the text of the Establishment Clause and its progeny, all the cases that came out of it, it does two things. It says specifically, unambiguously, you cannot either promote one religion or another, or you cannot disparage one religion against another. So when they specifically write in the bill, we're promoting this religion while disparaging this religion, conceivably, yes, that is an easier thing to challenge because they basically wrote into the bill itself, this is unconstitutional. They're directly violating it. There's no argument to be made. In a lot of our earlier things, a lot of our earlier lawsuits, you have to kind of get to the fact where, there was a pretext to keep us out, right? That was always our argument, as these are pretextual situations where they're creating a situation to exclude us. This is saying we're excluding you directly. So yeah, I mean, this should be
not giving even a rationale as to why they'd be excluding us. Forget a legal theory as to how you exclude us and make that square with the First Amendment. There's not even a reason as to why we should be excluded at all. And that to me that blows my mind. That is absurd.
And it's just playing off this. It's playing off this notion that that there's real Americans and not real Americans. And I think their hope is they're seeing like they want to take out whole swaths of American society that's alternative, whatever it may look like, race, sexual preference, religion, whatever it is. They're trying to boldly say, we want these people out of our society. And they're trying to get enough of these bills passed, as we've been seeing since the Project Blitz situation, where it kind of overwhelms anybody challenging it. And they know that these things are unpopular. I mean, it's the same with the reproductive rights. It's just they don't care. They're in power. They want to stay in power, and they want to crush anyone that's different. It's extremely fascist, and that word is thrown around way too much. But I mean, it's like by definition is you've got leaders calling people vermin. I mean, it's straight out of the playbook. And I mean, if this happened when we all were our first lawsuit launched 10 years ago now, this would have been mind blowing. But all of a sudden, this has become the norm. Like, these are the kind of things they're doing. But, hopefully the courts are savvy to this, which I think they are. I don't think these things are going to last. But what they're doing is they're going to try to push so many of them that something's going to get through. And they just are hoping for that one shot where they get that one fact pattern that it just completely destroys religious liberty, because that's their goal. Anyone that's pushing a religious liberty bill, what they're actually trying to do is destroy religious liberty. I mean, it's like, it's very doublespeak. They're trying to have a supremacy of their own religion and call that liberty. We all know that here, but hopefully the general public is getting more and more savvy to this over time.
What about you, Matt? Do you think there's a benefit to them being so flagrant when it comes to their references to us, when their motives are so clear and they lack in any cleverness, and we can't really say that this is insidious? Does that just benefit us in the courts?
Theoretically, yeah. I mean, I don't see how most judges would look at it and say, okay, yeah, this is religiously neutral. The issue that we're running into a lot is things are pretty obvious in our lawsuits, and yet we're still losing. Scottsdale, literally, they wrote a fucking op-ed that we put into evidence declaring exactly what they were going to do, exactly why they were going to do it, and we lost anyway. Boston, same. Belle Plaine, same. These are not, they were never savvy. What they're seeing
and I have to say something in defense of you both, because you both litigated the Arizona case for us in Scottsdale. Yeah. And it was by no, it was no ill thinking on your parts that resulted in that ruling. It was just proving the unprovable at that point. The judge put such a high burden of proof on the idea that we were discriminated against. All of the rhetoric against us was accepted. The animus against us from the city council was accepted. The fact that they had said they were going to do what they did, and then they did it, that was known and accepted as well. What it all ended up hinging on was it wasn't provable that that was what had actually happened, and it wasn't just a matter of administrative malfunction that caused us to be disregarded. And even though we lost, though, it wasn't really a victory of any substantial type for Scottsdale either. We can just go to Scottsdale again if they're having public prayers and say, well, this time let's do it right. We want to give a prayer. And the whole issue is opened again. So it was essentially the judge evading the issue. And that's what we've seen again and again. But we can't be certain that a judge isn't just going to make a completely asinine ruling in ways I think they have when they've thrown our cases out. We've seen asinine rulings in the way of disregarding our standing and things like that. But I think the courts are still really reticent to create precedent in really bad rulings. Even some of the worst judges, I think, really have reservations against that still, hopefully. And hopefully the judiciary can be counted on to not be as stupid as different state houses.
Well, most of them, yeah, but you have to get in the mind of your adversaries here. They're banking on, say, the Fifth Circuit, which Mississippi is in, and in which one of these bills arise. They're basically banking on the Fifth Circuit turning a blind eye to what the Establishment Clause means. Oh, suddenly it doesn't really protect the infidel.
Well, here on that note, since you brought up the Arizona case, I want to bring up two things that distinguish this bill from that situation. So, by the way, very good synopsis of that case. That's exactly what happened. But there were two things against us in the Scottsdale case, in my opinion. The first one was the action to actually boot us from that public forum wasn't done in the legislative chamber. It was done behind the scenes. That was one of the rulings. The second thing was that they didn't say it because we were Satanists. They said it was because we were out of town. That was what my whole thing was with the pretext. It really didn't, we know it didn't have to do with that, but all of the statements made about that were done outside of the legislative chamber. So that became a freedom of speech issue for these legislators, right? That's different here because this is a bill passed within the legislative body that specifically names us. We had neither of those facts in the Scottsdale case, or I don't know if we have in any of the ones. Matt would know better than I do at this point.
No.
We have we had that?
We have not had that. We did have in Belle Plaine a counselor say, I'm worried about satanic monuments going into this here free speech zone. So it's really close, but due to procedural shenanigans, the court was able to turn a blind eye to it.
So yeah, exactly. So even in our best cases that we've had, we didn't have those facts where it's directly
wasn't the text of the bill. Yeah,
it's directly naming us. I mean, that's wild to me. So that to answer your question, it should really, if we challenge this, that bill should go down. I'm hoping these things don't pass, but in this day and age, who knows?
10 out of 10 times it'll fail, but the opposition is trying to create that legal fight so that some asshole judge can say, oh, wait, no, actually, despite it being twice over proven, they're bona fides, they're not actually a real religion. Or
that's the thing. We have to go to court. We have to pay these bills. Like in Arkansas, we've been at this case. It's been 8 years now, or something like that. Something ridiculous. We've been fighting this Baphomet monument battle in Arkansas, and I have no idea how much money we've put into that so far. I find it funny that sometimes people accuse us of profiteering off these lawsuits. That certainly isn't a viable business model for anybody, and it's not something that brings in money. It loses money. This is where the money goes. But somebody asked in the chat, is there strategy to rapid fire these attacks and bankrupt TST? And I think we'd all be speculating, but my feeling is that's probably not the case, because even prior to TST, this has been going on for generations. The theocratic movement has been trying to take over, and it's not even it's a relatively new thing insofar as law goes. I think that we view religion now as this category that gets this kind of heightened super status, in which it doesn't have just equal rights with secular interests or anything like that, but it actually has heightened free speech rights. And I think, for a while, I think it was common practice that religion just was kept out of schools categorically, and that wasn't considered religious discrimination. Religious discrimination was when you allowed one religion in and didn't allow another. And that's the kind of traditional idea of religious discrimination I approach these questions from. And at the point where in 2001, the Supreme Court ruled in favor of after-school clubs being able to being allowed to use school facilities because they couldn't keep religion out if they were going to allow any secular clubs in, I think that was kind of a redefinition of religious liberty there, in a redefinition of religious discrimination, where categorically you couldn't exclude religion from anything. And I think they knew that was a redefinition. I think you had people like Clarence Thomas then, Alito, and Scalia at the time. And in his defense, Scalia did make it very clear that you could not discriminate against any type of religion or non-believers. And I think That's a really important thing that a lot of other atheist organizations, I think, kind of let go of in their rhetoric decrying all religion as poisonous, rather than realizing that religion was turning into a super category that was extra protected and had extra privileges, and deciding to assert themselves as having a religious viewpoint that was valid as something that deserved religious protection. I think that was something they let slip by them. And now we've gotten into a whole different conversation where we treat any type of non-belief not as a type of religious perspective, not as something that has any type of rights. But anyways, that's very much a digression from the original question, which is, are they doing this in rapid fire to bankrupt TST? And I don't think that's what they're doing necessarily. You might think otherwise, but I think this is something they always do, and I think it speaks more to some kind of acknowledgement on their part that they only need one as a starting point, right? It can be very much unconstitutional, but they've had some successes in the past. You get "In God We Trust" on money, and now they hold that up and wave a dollar bill and say, "See, this is a Christian nation." Whereas the argument prior to putting "In God We Trust" on money was that it was ceremonial, it was patriotic, it spoke to the heritage and history. God could really mean anything from any religious vantage point. And these are just, they'll take any win they can get. And part of that, I think, is this scattershot approach where they'll just push as many bills as they can to help build the narrative of a Christian nation. And from there, they'll build to more egregious violations. They're just in a fevered pitch to get more and more progress now.
Yeah, I wouldn't say, I would reframe it. I wouldn't say it's to bankrupt TST, but it's certainly to overwhelm the opposition, because, they called it Project Blitz. Fine term of art. We knew who came up with that terminology. Right,
you're right. They named it Project Blitz. It was revealed by other people, and it wasn't revealed by people who then named it Project Blitz. It was called Project Blitz in the background. So yeah. It does hearken to that blitzkrieg strategy.
It's lightning war. It means it come on as fast and furiously as possible to overwhelm your opposition. So yes, there is an element where I believe that's true. Now, is it to bankrupt us? I don't think it's a money thing. I mean, we're so unbelievably overpowered money-wise, and so is every other institution fighting this, that, I mean, they don't need to bankrupt us. But they do overwhelm us. I mean, the ACLU doesn't even have enough attorneys to fight this on every single front. So, and it's like you said, where if they get one case through one federal court that, as we've seen, or Supreme Court of a state that is sympathetic to this crazy cause, it's the law of the land, whether it's a state or the country. And all it takes is one. I mean, it's like the Roe v. Wade thing, that one case gets through and then everyone's rights are affected. So yeah, I think it is.
The scary reality is that we can only challenge so many of these things. We can only go to court for so many things. If we had more resources, we would certainly have more lawsuits and a larger legal team with you guys, but we don't. And we're fighting an opposition that are holding places in public office, and they're just spending the public money to do this. They're spending public funds. There's no consequence for them. Nothing's coming out of their paycheck in order to pursue these things. And that is frightening. So the rapid fire effect might not be directly motivated by the intention of bankrupting TST, but it does speak to the reality of the fact that they can just keep pursuing these things. And in order for us to combat them, we need to spend our own money to do it.
Yeah, we got some more questions here.
And the second one really gets to the heart of the matter. It says, what are the next steps to be taken regarding protecting our satanic rights? And I guess that's part of the purpose we're having these dialogues at all. Everything's moving in such rapid motion. I guess I should let people know that we will get on these calls and relay this information before we've had an opportunity to strategize an overall plan, or even in the midst of doing so, because it really is difficult to know. This is new terrain. There's a lot in this that hasn't been covered before. And I think we were talking about this, about how at least Matt and I were on a meeting earlier this week, and we were talking about it being perhaps precedent-setting law if we have to challenge chaplain requirements that insist on seminary training and that kind of thing, because that's far too Christian specific. But I don't think that's a battle that's been fought before. And I think we've got some more brutal long-term lawsuits that are probably going to drag out, some of them till after we're dead and gone. But a lot of that is happening now. And so I'll just punt that one to you guys and ask, what do you think we should be doing next regarding our satanic rights? I guess, with a special focus on what could we possibly do that's proactive at this point.
Well, I'll give the 101 on how these lawsuits work. So it goes back to what I was saying earlier with standing. So what has to happen is a law passes, and then someone's rights are violated by this law. That's the starting point. Because if no one's hurt by a law, there's no harm, no foul in the law, right? So if they pass a law, say, for example, Satanists can't be a part of the chaplain program. Well, what we do proactively is we've been creating this culture for a long time. We've put together legitimate ordination programs. We're doing everything by the numbers that a religion does, and keep building on that and building on this culture and its numbers and the history, and keep really being a legitimate religion, which we've been since the beginning, but they don't seem to see it unless there's enough people and enough time and, all this other, like I call it, pretextual stuff. But that's how you do it, is you just exist and you are a Satanist. And then what happens is one of those laws passes, and then one of our people who's legitimately ordained, who's legitimately one of our ministers, volunteers for that program. And when they say no, now that law has violated a specific person's rights. And then that person has to decide whether or not they want to be a plaintiff. And when you're a plaintiff in one of our cases, it's a pretty grueling situation for both the lawyers and that person, because there's a lot of media attention. Everyone's going to call you a phony and a fraud, and there's going to be all the hate mail and all that stuff. And then you just have to press at that lawsuit, and win or lose, it keeps going up until it makes precedent. And hopefully we win on that, because the big scary thing that could happen one day is one of these cases goes to the Supreme Court and we lose, because then what happens to religious liberty? Now it's turned into something it's never been intended. And it has to do with like the composition of the courts or whatever. So I'd say to protect our rights, we just be out and proud Satanists. We keep being a community, pro-social community, doing the things that we do in all of our good works. And eventually we'll get through. But what's unfortunately to challenge any of this stuff, a law has to pass and someone's rights have to be violated. It's the only way to fight it. And that's why we kind of, as the attorneys too, we kind of sit and wait and see what happens with these things.
I respectfully disagree that we have to wait on these particular laws. These are facially unconstitutional. It's very rare for a law, a statute in and of itself, to, within the four corners of the text, on its face, be unconstitutional. But this is it.
I still think we need standing, though.
Say again?
Do you think we need standing, though, to challenge it?
We have standing for sure. It's TST. They're specifically excluding Satanists. TST is the most famous satanic religious organization. Who but us would have standing?
I still think
though, that most people listening are not concerned as to how we'll litigate this, because that time will come. But as for what they can do, and I do agree they should be out and proud if they can, if circumstances allow for that. But if they do, certainly do it. And even if you have an account set up under an anonymous name online, and you're speaking on behalf of these kinds of things, go for it. Go ahead. I mean, that happens all the time in all the other camps. But I think something people should realize too is how little we're actually working with. I talk to people sometimes and they assume that I actually have a research team, or that, I think either one of you might. And in reality, there's a pretty small core group of us working on these types of things. And there's still a lot of research I haven't done because there's so much popping up. There's people's backgrounds I want to look into, some of the politicians who've been involved in these types of things. There's a Utah bill that came out and was trying to illegalize satanic ritual abuse, harkening back to real 1980s satanic panic shit. And that's a whole different topic right there. But I wanted to look into some of the people who are giving testimony on that, because I'm sure they play into our Grey Faction files. They probably overlap pretty heavily. And if you're interested in trying to learn what I'm talking about there, because maybe you don't understand, look at our work on greyfaction.org. Grey Faction's a campaign of ours that fights back against satanic panic rhetoric and bullshit and official satanic panic stuff in any case. But anyways, if you are in an area where they're trying to put forward chaplain bills, and that's something you're interested, certainly reach out. But also look into the qualifications and look if there's any qualifications there that trouble you, that you think are outside the reality of what they could expect from a non-Christian chaplain. Look into the specifics locally of what it takes and what you can do, and feel free to forward that to us at some point. We can oftentimes use that kind of work, and it doesn't take necessarily sending us money if volunteers are willing and able to put in volunteer man hours to do any of this work. That's greatly appreciated too. That just takes away some of the workload that we have, and all of that helps. And again, I was talking about being out loud about this, letting people see that yes, these bills being proposed really are looking to intrude on the rights of real people, because I think in too many people's minds this is entirely hypothetical. And I think what we're seeing is that people really aren't talking about this. Self-identified Satanists, membership of TST, I don't think there's been a whole lot of chatter, at least not what I would think would be equivalent to the attempts upon us. And I think they're unsure about what their limits are in reference to the Johnson Amendment and the fact that we are a 501c3 recognized church, in that we are supposed to be limited from political engagement. And I think it would be helpful maybe if we went over, again, some of the Johnson Amendment restrictions and requirements that we have to abide by, and beyond which we can just go off.
The Johnson Amendment at its barest bottom precludes us from intervening in elections. That is really the concern of the Johnson Amendment, to preclude nonprofit organizations, which is more than just TSC, of course. Any kind of nonprofit organization should not be an electioneering organization. That's why Citizens United was such a big deal. But anyway, the point being is that with regard to Johnson Amendment, we just can't involve in an election. Don't say vote for candidate X over candidate Y. Don't, if you're going to produce voter information, you have to be very neutral about the information that is being disseminated. You can't say, for example, we're a nonprofit specifically for the purpose of advocating for a particular political party.
Let me just flesh that out a little further for anyone that doesn't know what the Johnson Amendment really is basically you can't from the pulpit tell people who to vote for. And the consequence of that is supposed to be you lose your tax exempt status. Of course, we see evangelicals doing this constantly, vote for Trump. But imagine the money laundering that could happen, where you donate a shit ton of money to some church, tax exempt, and then you have them say, oh, we gave you a generous donation. Why don't you tell your flock who the good guy is here. Can you? I mean, it's just complete chaos. But that's why what I think has happened with the evangelicals is it's no longer a religion; it's a political party, because that's what happens when you mix church and state. It's catastrophic to both entities. So yeah, don't tell people who to vote for.
But if you see me on Twitter, I'm often harassing politicians directly. And in fact, I try to, when I'm beat up on people who are consequential in some ways. I don't like necessarily to get into conflicts, especially not online. I know that I have more followers sometimes than some of the people I'm beating up on, and you have to keep in mind that kind of imbalance as well. And also, I know how horrific it is when an angry mob is coming at you. So I like to make sure I'm only directing my outrage at either another angry mob or somebody who has some kind of consequential say in what can be done. But with that being said, I can be pretty brutal when it gets there, and I'm quite insulting towards these politicians, and I feel like that's okay. I mean, that's kind of an ethical character call as to how you want to present yourself. But I don't think you have to worry about that on a Johnson Amendment front when you have a real disagreement with a politician who is actually doing things that are impacting you negatively. You can still call this person an asshole. Just don't say anything about voting, and don't generalize it to their party or as in a wider political context. I sent former Senator Jason Rapert in Arkansas a Valentine's card over Twitter, a little video Valentine's card. You can check my Twitter feed back for Valentine's Day to see what it was. But so if you're wondering though, just how you can be, how you can properly act in these conditions, the Johnson Amendment consideration is only insofar as politicking for candidates or parties, and disparaging any of them is fine.
There's just an issue.
Well,
yeah.
Hold on. I
Right.
want to emphasize the why as to why what you're saying is true. It's because you are not speaking in your capacity as a media spokesperson for TST. If TST Twitter page was saying the exact same things that you were saying and doing the exact same things you were doing, that might be a problem, but it really becomes a problem when it's an election season. So, it's true what you're saying, because you're not doing it as TST, because, these statements aren't in connection with electioneering. You're not saying, this guy's a stupid asshole, vote against him, on whatever day. You see what I'm saying? Those two.
Yeah, no, you make an important distinction. So if we have congregation heads listening, I wouldn't use your congregation's general social media for any of this, but your personal, have at it, please. The more the merrier. Jump in in the comments. I'm there. We're all there. Be a happy, good time, and people should really see people making a mockery of how stupid this is, because I think that's what we're tasked with right now. Some of these bills are so stupid, and there's no consequence currently to the people who are putting their sponsorship to them. Let's make there be a consequence. Let's do everything we can to get people to recognize how stupid these things are. And I try to do that when I go on local news broadcasts or even nationwide ones or whatever. Oftentimes that rhetoric gets cut out. But the more we can do to point and say, you may have made this easier for Satanists and you're stupid, it could help.
I have one request for the general TST population, and do it smartly. And it's not a high bar to be smarter than these people, but just surprise them by not calling them a doo-doo head or something. Just be really savvy about it. And the more people that do that, the more I think they're like, shit, when I do this stuff, I'm going to have people actually intelligently arguing with me, because I think it's what they don't expect. And I just feel like over time, you know, I know we're always going to be somewhat of a black t-shirt convention, but at the same time, it's like we've got a lot of smart people that are calling out people that need to be called out. And I think that that pressure needs to have consequences where eventually this will lead to a lawsuit. But yeah, the more logical of an argument and the smarter you can be, and the more pressure we put on them, they're going to realize. I mean, that's why this is all happening, is they know who we are, which is a double-edged sword, of course. But I think they're making mistakes.
Well, somebody did ask, how can we offer volunteer research support? And I'm glad they asked. And the answer is, you know, go to tst.link/contact and fill out the contact form on our website, and somebody will see it. And I guarantee you, you know, it will be, if it's helpful material, it will be helpful. It will be noticed, and it will be utilized, and we can use that. Like, again, I can't emphasize that enough. We're just a small group of people doing things individually for the most part, and then we have our meetings and our discussions. But you know, to have any other people actively to crowdsource any amount of that work, especially now, is massive for us. It's again, I can't overstate it. Another question that had come in is, have we figured out who the real authors of this bill mill legislation is yet? And that's still another question. I think it'll be easier to find out as we collect more of a consensus of names from the people who have offered their sponsorship to these different bills. Certainly the lead sponsors are probably attached to whatever organization this is. If it's the AHHF under Rapert out of Arkansas, or it's some other upstart group, I'm still putting money on it not being one of the old time groups, and that there's a new group in town, because these bills are so remarkably stupid. I can't imagine the Congressional Prayer Caucus or the ADF had any part in some of these, or maybe it's one of the bill mill groups that was previously dedicated to anti-abortion legislation is now trying their hand at other things. I think we'll figure it out. And you know, a little anecdotally interesting thing here, which I want to bring up partially out of spite, is that we've developed professional relationships with people who have worked professionally with our opposition. And people get very angry about that sometimes, and they think that we are going to get tainted and that we'll become this kind of, or at least the optics will be such that will be seen as this crypto-fascist group if we have any such affiliations. Like, we work with a First Amendment lawyer who's defended people on the other side and things like that. Well, the upshot is that we have somebody with professional contacts within the opposition who said he's going to try to find out who's written these bills. And you can't pay for that kind of insight. You know what I mean? Like, these are the kinds of things, these are the kind of relationships we're building and the connections we have because we take this fight seriously, because we're not worried about optics more so than we are our rights. And we're going to go through this, you know, we're going to go full bore ahead and try to win this thing in any real way that we can. And I think that's an important thing for people to realize too.
I'd like to cover the Scottsdale question. It says, in a case like Scottsdale, is there an appeals process you can follow to go up the chain?
Yeah, well, I'll let you. I'll let you cover how that one went.
Yeah,
as it turns out,
the difficulty in any appeal. I do a lot of appeals. The difficulty in any appeal is that on fact questions, the appellate court, which is the next level up from the trial court, are going to defer to the fact findings of the trial court. Why? Because the appellate court is looking at text on a piece of paper, whereas the trial judge was able to witness the demeanor of the witnesses. You know, the theory goes that there's a whole lot of body language. Judges at the trial level are tasked, or juries, depending on the circumstances. But in our cases, you don't get a jury trial. Our cases are bench trials because they're mixed questions of fact and law. Anyway, long and short of it is appeals courts say, okay, well, whatever the trial judge says goes. And so the trial judge said, well, the person who they say made the decision said on the stand that he's not a bigot. And this is a religious discrimination case. So without some evidence of bigotry, I'm not going to find for the plaintiff, which is us. You can appeal all you want, but the appellate court says he looked at him. He gave him his judicial seal of approval, and therefore you lose. So there is an appellate process. The appellate process ordinarily is something that you want to be on a law issue, not a fact issue. So, for example, in Boston, we lose on a motion for summary judgment, which is a legal question. Is there a contest of facts such that I actually need to hear from the witnesses and make a determination as to what actually happened? Trials are expensive, you see. So that's a good appeal. Not saying we're going to win it because, you know, the courts have been very willing to turn a blind eye to the plight of the Satanists right now. But it's a hell of a lot better than showing up at the trial and the judge saying, well, I heard from all the counselors and they all said they don't have any problem with you. So you're just not getting invited as a matter of coincidence or whatever.
This is a good distinction from what Lucien was asking about when they're so flagrantly naming us as who they're excluding. So to back up a little bit with what Matt was saying, just to contextualize some of it. So a bench trial, for those who don't know, is a trial just to the judge instead of a jury of people. So when you have questions of fact, meaning we need somebody to figure out what the facts actually were because there's a dispute here of what the reality of the situation is, and law. If it's purely law, it's a lot easier to appeal. They look at it, it's called de novo from the beginning. They look at it from scratch. And when you're looking at a piece of paper, you can interpret the law from that. But the problem we had in Scottsdale was it hinged on the fact of the matter of whether or not this individual discriminated against us because we were from another town or because we were Satanists. So when you bring that up on appeal, if that's what it hangs on, they're going to defer to the people, the judge in this case, who saw that man testify, because also all they see is text. So it's extremely hard to win an appeal on a fact issue. And I think that applies. I mean, I'm mostly a criminal lawyer, and it applies the exact same way in criminal law, where if you've got a fact issue, they're going to defer to the trial court. If it was a purely legal question, at least you have more of a chance because the text is the text. It doesn't matter who was, how that's interpreted. Is that a decent way to describe that, Matt?
Yeah, I agree. I do a lot of criminal appeals. You do not want to argue facts in criminal court on appeal. In criminal court on appeal, you had a jury trial, and the jury trial questions whether there's substantial evidence, meaning basically any evidence to support the jury's verdict, which there's always going to be a contest of fact in criminal court. Hence the trial.
Before we get to the next question, I wanted to interject a question here, and this might be outside the purview of the discussion a little bit and might require some research, but is there any cases you can think of where litigation has been brought to change laws because the facts upon which a previous ruling were predicated upon were sufficiently deemed debunked? That might be confusing, so let me give the direct example. When the Supreme Court ruled in favor of Christian after-school clubs, the Good News Clubs, going into public schools, part of the rationale put forward by Clarence Thomas was based on the reasonable man standard. And sometimes, judges invoke this idea of the reasonable man. And what is a reasonable person going to see and perceive of this? And according to Clarence Thomas, the reasonable man would not see an after-school club as being something that was within the curriculum of the school district. It was not going to be something that the school district had ownership of. It was not going to be something endorsed by the school board. And in his mind, according to his opinion written, was that even children would be able to make this distinction. Children would know that this really had nothing to do with the school. So this idea that they were advocating for any religious viewpoints, he rendered absurd in his ruling. And of course, we see how untrue that is with rolling out the after-school Satan clubs, and how entire communities melt down. They go before the school boards and demand the school boards stop it, showing that the entirety of Clarence Thomas's rationale in regards to the reasonable man standard were absolutely false. With that in mind, could a school district then again try to make the argument to categorically exclude religion and relitigate this entire idea? Or does that seem out of the question? No, I got you, didn't I?
It's a long question.
It's a long question. Yeah, I was like, where do we start on this one?
All right, just boiling it down though, like the facts as presented to come up with a ruling are, I think, sufficiently proven false. Does that give grounds for relitigating the entire issue?
I'll start with this. So oftentimes you look at the dissenting opinions, right? So one side gets their ass handed to them in every lawsuit, and that gives me solace. So somebody loses, and the dissenting opinion is like, this is wrong, and in the future you're going to see how wrong this is. It happens all the time, and it could be 10, 20, 30 years, and it does get relitigated, and then they'll say that dissent that happened 30 years ago, they were right about that, and the times have changed, and precedents change over time, but sometimes it takes a generation. So yes, it's absolutely possible to relitigate and to have a different opinion. That's often the original dissenting opinion. The standard on appeal that you're, on a factual basis is going to be what's called abuse of discretion, which is just a much higher standard than they misapplied the law, right? But wait, there was another part of your question. I'm lost in the sauce here.
No. The core of the question was, is revelation of differing facts that disprove what a ruling was predicated upon provides some sufficient impetus to relitigate the entire decision.
Sure.
My example was the after-school Satan clubs, because.
Yeah, real quick, but let me finish. I'm going to finish this thought. Matt probably knows a lot more about this. He does a lot more appeals. I mostly do trials. But the reasonable person standard, that's what I was going to get to. The whole concept of the reasonable person standard, which is throughout law, is it's supposed to be the objective standard. What would any person in our society think of this? But the problem with it is it's always subjective, because each one of us thinks they're reasonable and wants to apply that standard with our own view of it, right? So the reasonable person standard is theoretically sound, but how objective is it, especially when you see a ruling like that where clearly that was that guy's opinion of what he thinks is reasonable? So anyway, Matt, you probably know more about all this appeal stuff.
Well, it's, in my experience, it's not a fact. Fact questions on appeal are not abuse of discretion. Fact questions are ordinarily clearly erroneous if by the trial judge or if by jury. I know in criminal court for sure it's substantial evidence. I'm pretty sure it's the same thing in civil court. But in any event, with I got lost in the sauce myself. What exactly is the question? Oh, relitigating. Relitigating is not a thing. So, for example, we have stare decisis, which, as we all know, Roe v. Wade is no longer a thing. In order for them to overturn Roe v. Wade and say, aha, actually, there's not an implied constitution. Sorry, our bad. The past 50 years have been a sham. They have to go over and above your ordinary decision to say, this is how we feel. You also have to take the next step and say, what we ruled previously was egregiously wrong. For every Roe v. Wade, there's also a Dred Scott decision where it's like, oh shit, actually that's really bad. We shouldn't have done that. So in terms of,
nobody knows what Dred Scott is, though.
Say again?
Describe the Dred Scott decision for just to...
I don't actually know the full con law was a long time ago. If it's not First Amendment, I don't really remember it too well. But basically, as I understand it, they said blacks aren't real people, therefore you can be owned as property, as chattel.
And that was the law of the land. But it takes a separate lawsuit to overturn that.
Yeah, I mean, eventually that legal principle is subsequently overturned. That was Brown versus Board of Education. That was 14th Amendment case, equal protection, that basically said, actually, we are, entitled to equal rights. See the 14th Amendment, which I think Dred Scott, was that before or after the 14th Amendment? I think it was an 1860 case, so probably before.
The point is, you're right. Con law was a long time for me too. The point is, though, you can't relitigate the same case. What has to happen is something comes up that creates a different lawsuit, and they're looking at the precedent to say this is by the precedent how this should be ruled on, and they have to collectively say, I think they got it wrong. I think we really fucked this up back in the day, and we need to change this. That does happen, but when it happens, it's monumental because that changes the whole course of American jurisprudence. So yes, it can happen. It does happen. Those cases are some of the most well-known cases that you have to learn in law school, for example. But it doesn't happen every day.
Right.
I want to qualify what you just said. It does frequently happen that cases will get overturned, but in terms of con law cases, fundamental rights stuff, that's very rare. I mean, the other cases too is ordinarily very rare, but it's not monumental.
Con law, that's where we're operating here. But that's like what fundamental rights cases, when those get overturned, I mean, that goes in the law books because that's a huge deal.
Oh, yeah.
But I know it wouldn't be the same case over again. But do you think a school district could possibly say, look, we don't want these religious battles in our school, and we want to say no to having religious after-school clubs? Do you think they could take that to court, or if that would be an immediate no? This is already established law.
You can make the argument. Lawyers do that shit all the time. They can say, yeah, this is wrong because, and they're shooting for a stare decisis argument. But
somebody asked the burning question: how are these politicians not being held accountable for putting forth such blatantly unconstitutional bills? They swore an oath to the Constitution. No, and I mean, this is something we've discussed. There really aren't any repercussions. The idea, the theory is that the voters take them to task. So I guess they've kind of pushed off the responsibility to us to make sure that people know how incompetent these people are, in that, we make the pitch that this unconstitutional behavior is not just something that is irritating to us and is of concern to us, but should be important overall. And I guess that speaks to Stu's advice of trying to sound smart and maybe not necessarily just hurling insults, but really making a case and making it clear why we're passionate about this, and that it isn't just some self-serving notion we have about ourselves, but making sure people know what kind of ripple effect this behavior has. And to me, that kind of ties in to the other question we got: why isn't the media covering the nationwide legislative attack on religious pluralism? And there again, I think it's on us. I think for some of the media, they don't want to argue on our behalf. They might agree with what we're saying, but they don't think the optics are good in putting it on Satanists and having Satanists be the kind of central figureheads for this fight. I mean, look at somebody like Rachel Maddow. I think it's kind of cowardly that she covers reproductive rights all the time in the way that she does. I think it's a nightly thing for her, yet has somehow managed to not mention the Satanic Temple once in our battles for reproductive rights. So in some ways we're out on our own, but in other ways, I think when you share articles about this, when you write things about this, and when some of the other, even more obscure local networks cover this and see a real reaction and distribution from us, that does further encourage other people, because ultimately the business model is in gaining clicks. It's not necessarily anything else. And, Fox is happy to have me on and make some of their hosts look like a fool, and but people go to see it. People, all they care about is the ratings in the evening. And so if it starts at the grassroots level and we're getting engaged and people are writing letters to the editor, and I think that's another thing, people are concerned about whether they can represent TST or not. You don't have to. You can say you're not representing TST. You can just say you're a Satanist. You can say you identify as a member of the Satanic Temple, but that you don't speak for the Satanic Temple, and then just go from there. Then everything you say is your own. And these are things worth doing. These are things worth talking about. These are attacks the likes of which they're not emboldened to launch against many other people, but they're emboldened to launch them against us. And we're only a starting point for them, too. They want to secure their supremacy, and then they'll exercise that and flex it in any way they can. So, we can't let this slip by. We're on the very front line, and we can't let them break through.
And to those points, I have a commentary on both of the first question about the blatantly unconstitutional bills. That happens all the time. I mean, it's the fact of the matter is, it's just like Lucien said, it's down to the voters. When you see an incompetent, anti-constitutional representative, the idea is we vote them out, especially when they waste taxpayer money to fight these cases. My theory on this is Americans are so used to their taxpayer money being thrown into a bonfire that that part isn't even paid attention to anymore. I mean, between the wars and the corporate bailouts and all this other stuff, like, we pay shit tons of taxes. We don't get anything for it. There's still the potholes in the roads. So when there's another taxpayer money lawsuit being thrown at a bonfire, I just don't even think people pay attention. Like, how could you? It just happens at every turn. But I think the more ignorant the population is, the more ignorant our politicians are. And I don't, that's the democratic process, baby. That's how it all pans out. But hopefully they, like Lucien also said, they're going to wise up to this as we keep going. And as far as the media coverage, I've seen more media coverage about this than I've ever seen. When we were starting to do this in 2016, there was media coverage of it, but it was like, oh, wow, someone's paying attention. I've seen more TST articles in the last year than collectively the whole decade before, between the after school programs. Just today, literally just today on my home screen at work, I saw our Baphomet monument just like randomly in the national news because of some of these bills. So the media is covering it, and it's a slow burn because we're not sympathetic. And that's something we're all going to have to just swallow, is Satanists are not a sympathetic bunch. No one's really going to, in the whole scheme of the oppressed and the people that are downtrodden, we're pretty low on the scale of people that are going to be defended by the media. But I will say there's been a lot of coverage lately compared to normal. So I think over time, this has been a huge success of people paying attention.
Again, though, I think people's commentary in the media, in comments, letters to the editor if you feel up to it, that kind of thing. I honestly think that is really meaningful because I remember when we first started also, there was never a positive article about us. The best we would see are articles where somebody would say, sure, you hate them, but they have a point on this one issue.
Right.
And I feel like it wasn't until people were willing to get into the comments and say, I don't only think they have a point, I like them, and start really advocating for our viewpoint and say, we have our rights and there's actually nothing objectionable here. So fuck off. I think that was what really emboldened other editorial writers even to maybe take that viewpoint, to maybe take a more neutral view towards us, knowing that they weren't necessarily going to get piled upon by people who just didn't understand one way or the other. I really think jumping into comments and just being, and even a brief statement like, yeah, they're right, that's what the law is and that's what it should be. That's beneficial. That's something we can all do. Did we have anything else we thought we should discuss? We're already heading over an hour here, so
I think we covered a lot of ground. This stuff, like you said, it's moving fast. Bills are getting proposed, bills are getting shut down. It's a wild time right now for us, I think.
Yeah, and we have future discussions, live streaming already planned for bigger topics on some of these things that popped up. And we want to talk about like the Utah anti-ritual abuse bill individually and get Grafe action on the stream and things like that. But of course, keep up with us for the updates. Look at the social media and stay aware and stay engaged. Thank you, fellas.
Yes, thanks for having us, and thanks for watching, everybody.
Until next time.
Yes.